let's go to, are we going to Colorado? Is that, where did this, where did the Charlie Kirk shooting happen? I think it's in Colorado. Let's go to Colorado. I'm going to show you how Tyler Robinson arrived to court today. Follow me.
Go to the lobby. Let's all go to the lobby. Let's all go to the lobby to get ourselves a treat.
Axum says, Broski got the methylene blue tongue. You know it. You know it. So I think he's actually in the freaking armored truck. How crazy is that? Utah? Thank you, Andy. The dude's in the armored truck. Sedan says a pillow is a perfect product to manufacture. Packs tight, ships light, and low risk of consumer injuries. That's a great point, Sedan. That's awesome, Sedan. I never thought of it that way. Is he not in the truck? He is in the armored truck. That's insane. All right, we're going inside the courthouse now, my friends. I don't know how much of this we're going to watch together. I think they take a long, long, long break, and they come back a little bit later on. Let's see. Let's wing it. Dome in the courtroom.
All rise. Court is being used now second. The Honorable Tony F. Jr. presiding.
All right, here's our
Please
judge.
be seated.
Here's our judge. Here's our judgy judge. Judgy nice hair.
Court is now in session. Counsel, if you could enter your appearances, please.
He had to tweet something out right there.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me.
Sounds
Richard
like
Novak,
Mike Lindell.
Stacey Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
What does that mean? Media interveners?
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler
Willis,
James
welcome
Robinson.
in, Willis. I call
Counsel,
him Willie again.
as we're moving forward today, I want to give an overview of what we anticipate doing.
Okay.
And it comes down, we're addressing three issues.
Ballyho Dustin.
The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript
Elite Never Habs is praying they call Candace Owens to stand for questioning
of that hearing. The second is the state's motion to amend or clarify the publicity order,
Habs is funny
commonly
tonight.
known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording, the record should remain sealed. All members of the public and the press.
Why would anything be sealed? I don't understand. He looked right at us when he said public.
Will be excused, and the hearing will not be broadcast. This is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties or the public and the media to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's
Stop
order
looking
that
at me.
transmission be terminated temporarily.
I don't think
Your
this
Honor,
guy.
we have one request.
I don't think this guy is used to having cameras inside of his courtroom. He knows that like thousands and thousands of people are watching him today.
With respect to the closed hearing, may I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
If we can't watch, they can't watch.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with
There he is,
Mr.
right
Robinson,
here. There he
and
is.
they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it.
Good.
I believe it is appropriate to treat all parties in the public equally, though I do recognize
Thank you, sir.
Their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you.
All right, closed session. They were in a closed session for like freaking hours. What the hell is this? Why is it showing me that something's there if something's not there? Jesus. All right, here we go. What the hell was that, says Willis. I don't know, Willis.
So there is
The closed session.
All right. I don't know how the hell we're going to cover this in the future. I wish I could get some time off and do, if they do televise it, I would have loved to do this thing live the whole way. Can you unmute your mic, Judge?
We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before.
He's adjusting his green screen like I do.
And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it
Already?
relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice. If the judge makes particular findings and that the specific circumstances warrant it.
Can you hear everybody?
It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is
Oh my God, not the shackles!
also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there has been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation, but we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent.
He's a criminal.
We apologize for that.
He's in jail.
They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information.
Not Sharon's here says they don't want us to watch. So you think this stuff is being done on purpose to make sure, because they haven't ruled yet if they will allow cameras in during the actual trial. Do you think this is some tomfoolery to make sure that cameras won't be live during this?
About that and whether that's a violation. Filming of the computers
is not a
violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter of the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen.
Ice-T, Willis.
We're trying to correct as much as we can on that.
Unsweet.
But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter. The court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
360 joining us for the very first time inside the chat. Everyone give a ballyho to 360. Founding Fathers inside the chat. What's up, Founding Fathers?
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restart it. So it's still a problem.
Thank you.
Well, maybe he shouldn't have shot Charlie Kirk.
Weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings, and again, if there are specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the
Ballyho,
session.
Don't Stop Believing.
And cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward.
Let's get one more shot of the shackles.
Trying to do the best we
What do you think, Dome? Are we into this? We got opening statements coming. We should watch the opening statements, I feel, shouldn't we?
All right. Let's go ahead and address the state's motion to amend or clarify the publicity order. And I'll hear from all parties. And I know it has been briefed, but in responses, but I'll hear brief argument, and then we can go from there. Mr. Ballard.
Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same goal, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once.
You better.
The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case?
I mean, if it's witnesses, everyone saw this, bro.
or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team, because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So
I don't know what he's talking about either, lady.
with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team, because if that term stretches beyond just the prosecution team, then the order as written, we don't believe is a valid and lawful order, because it would result in a prior restraint on certain speech, and at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty
I don't think we're going to be able to fit the Egyptian planes through this door to question them, guys.
to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order, and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns, because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored.
This isn't defense ex-Canadian.
As the state has explained,
state.
The Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with a criminal case. You have attorneys.
Looks like every single fucking loser liberal out there, doesn't he?
Trial participants. Certainly, the court has the highest degree of ability to be able to restrain the speech of attorneys. And in fact, as I've expressed, the ethical rules require that. But when it comes to
no
trial
chin, no
participants,
jaw,
like witnesses,
no
the
soul.
standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding.
He looks like
And I
Aspen
think
Gold
the court
says,
also
"All you
needs
can
to
eat."
note that there are there are several people associated with this case who have very significant interests in exercising their First Amendment rights, in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that
Are we
into
talking about like
consideration
podcasters that could be
if this order
called
is meant to apply beyond just the
as
prosecution
witnesses?
team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean.
Hab says, imagine what a shit show this will become if they call podcasters to testify. Can you wear a beanie in a courtroom? Good question, Habs. I don't know how long we're going to stick with this. I mean, this is something that I wouldn't mind watching live in the moment. But I mean, we got. I don't know if we can do this every single night, guys, when this happens.
For the state.
No, thank you,
Okay, thank
Mr.
you.
Ballard. Mr. Novak.
Thank you, Your Honor.
Do you need sleeves in the courtroom? Good question, Andy.
I'm going to try to be brief because our views on the propriety of the court's order.
This is the shooter's
were
lawyer,
set forth
everybody.
in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at...
Eric 7712 invested $1.
Eric says, from the evidence I saw, this boy did not hit his target. The bullet appeared to come from Charlie's right, not the left. He is a patsy like Lee Harvey Oswald, says Elite Domer. Eric, thank you, Eric.
The conduct of and the court's expectations for counsel.
Welcome in,
So
UFO Johnny.
even if, under that order that the court issued, somebody who we could all agree is a witness within
Let's stay here for 5 more
court's
minutes at
definition
least.
of that,
We'll take it to the top of the hour.
made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term.
Sharon's
So
here. We'll be here. She's just running a little late tonight.
it is our view
I
that
think
the
she's
court's
gonna be here.
order It's not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second. Because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue, and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be.
Elite Dumber Habs, does this mean I'm the interim speaker of the Dome? Oh, dear God, if that happens, this whole place is falling apart. Ladies and gentlemen, Sharon's here. Speaker of the Dome has arrived. Let's get some ballyhos in the chat.
Why, in our papers, we refer to it as a
all right, let's watch Trump.
potential.
If we were going to do this, we got to do it live. Like, I would love to watch the trial. I think that doming the trial would be great content. I do. But when we only do a 3-hour stream at night, we're not going to be able to do a 6-hour, 8-hour court appearance. How long do court days usually last? I don't know. It's been forever since I've been to court. Sedan says no more Fantasyland playtime for that guy anymore. I agree. All You Can Eat says do it live. I still have a day job. All You Can Eat. We're working on it, but I still have a day job. Hit that red subscribe button, everybody, and I won't have a day job for long. Sharon's here says ballyho to everybody. She's saying her hellos. All right, my friends, as you're saying hi to Sharon's here, we're going to take a quick musical break. We'll be right back. President Trump, a Politico sit-down interview that happened about 2 days ago. We're bringing it to you. We'll be right back after this.